Parker won in 1 year. I fought for 15. The only difference was a newspaper. If you're asking yourself how to beat federal charges before they ever reach a jury, I want to show you something. This is not a theory, not a strategy overview, a direct comparison between two real people who faced federal charges in the same courthouse with the same defense attorney at different points in time. One of them won in less than a year. The case was dismissed before it ever went to the jury. The other fought for 15 years, survived a wrongful conviction, and did not get his vindication until 2024. I am the one who fought for 15 years. And I'm going to tell you exactly what the difference was, because that difference is the mistake that cost people everything, and it's a mistake that you do not have to make. My name is Michael Quiel. I am the CEO of the U.S. Observer, an investigative newspaper and advocacy organization that was founded in 1991. I am not an attorney. I cannot give you legal advice. What I can give you is 35 years of experience watching cases won and lost, and the direct personal experience of knowing what it feels like to have a tool available that could have shortened my fight and not knowing it was available until it was almost too late. These are two similar cases. Same courthouse, same attorney. I want to start with the man named James Parker. Parker wrote a strong testimonial of our win. The facts of his case are real, and the comparison I'm about ready to make is accurate. Parker faced federal charges in Phoenix court. He retained Michael Minns as his defense attorney. Minns is one of the best criminal tax defense attorneys in the country. Parker was also represented from the start of his case by the U.S. Observer. Our investigators went into work immediately. They documented what the government had examined the evidence behind the charges and made sure that the truth was not only known by Parker's legal team, but visible in the public record. The charges went against Parker were serious. The government believed it had a case. The U.S. Observer published on the case. Defense attorney Michael Minns filed a motion, Rule 29. That is a motion for judgment of acquittal, arguing that the government has not presented sufficient evidence for a reasonable jury to convict. The motion was granted. The case was dismissed before the jury ever rendered a verdict. Parker walked out of that courtroom fully vindicated. From beginning to end, it took 1 year. Now, here is where I come in. I faced federal charges in federal court. I retained Michael Minns as my defense attorney. Same courthouse, same attorney. I did not have the U.S. Observer. My case dragged for 15 years. I was convicted at an initial trial in 2013. I fought that conviction through multiple appeals. I finally went back to trial in 2024, where 8 jurors deliberated for 4 hours and came back unanimous. 15 years, a conviction in the middle, a wrongful prosecution built on forged documents and testimony of disbarred attorney who had become paid government informant. All of it finally resolved in 2024. Same courthouse, same attorney, 14 years of difference. I want you to sit with that for a moment. The one thing that was different, I did not get the U.S. Observer working on my case until 2017. 6 years before the victory, but 14 years into the fight, Parker had U.S. Observer from day one. That is the difference. Not the attorney, not the courthouse, not the category of charges, not the fundamental facts of the case. The one variable that separates a case that ends in 1 year from a case that grinds on for 15 is whether the truth was documented, investigated, and placed into the public record from the beginning in a form that attorneys cannot legally provide themselves. I want to tell you how I found this out because this is the part that still lands hard when I think about it. When I learned that Parker had been represented by U.S. Observer from the start of this case, I understood something that I wish I had understood years earlier. The U.S. Observer was founded in 1991. It has produced results for other people for more than 3 decades. And I had not used it for myself because I assumed, the way most people assume, that my attorney had everything covered, that the legal defense was the defense, that nothing outside the courtroom could change what happened inside it. Michael Minns could not tell me about the U.S. Observer because of Rule 3.6. I was wrong thinking that my lawyer had it covered. What the newspaper does, the attorney cannot. Michael Minns is a great attorney. I am not saying otherwise. What I am saying is that even the best criminal defense attorney in the country operates under constraints that have nothing to do with their skill and everything to do with the rules that govern them. ABA Model Rule 3.6, which most states have adopted in some form, restrict that defense attorney can say anything publicly about a pending case. It limits their ability to apply public pressure, to publicly expose prosecutorial misconduct, or to shape the information or the environment around the case in ways that might affect potential jurors and the public understanding of what's actually happening. Your attorney is good at what they do, but what they can do has a defined edge. And beyond that edge, the government can build its narrative, shape the public perception, and move its case forward in a space where no one is pushing back. That is exactly where the U.S. Observer operates. When we are on a case, from the beginning, we are investigating the government's evidence, examining the witnesses, identifying what does not hold up, putting documented truth into the public record. We are not giving legal advice. We are doing journalism. First Amendment, protected journalism that prosecutors have to account for in a way that they do not have to account for anything a defense attorney says privately in a motion. Parker had that working from him the first day of his case. I did not. The question is not whether to fight. I hear from people all the time who are weighing whether to fight, whether the odds are worth it, whether the system is too stacked, whether they should just take the deal and end it. I understand that calculation. I lived it for 15 years. I know what it costs. But here's the thing I want you to take out of this video. The question is not whether to fight. The question is whether you're going to fight with every tool available, or whether you're going to leave the most powerful one on the table. Parker did not just hire a great attorney. He also made sure that the truth was being worked on from outside the courtroom, in a space no attorney could touch. The combination of those two things produced a case of dismissal before it ever went to a jury. I had the great attorney. I did not have the newspaper until post-conviction. My case would have unfolded differently if the U.S. Observer had been working on it from 2009. What I know is the outcome when both pieces are in place. And what I know about Parker's case is what the outcome looks like when both pieces are in place from the beginning. That contrast is real. The timing is real. The results speak for themselves. If you're facing charges right now or trying to help someone who is, the time to make sure every tool is in play is not after the first trial ends. It's now, before the government has time to harden its narrative. Before, the only version of events most people know is the one the prosecution is telling. Parker's case took 1 year. Mine took 15. I know which one I would choose. In the next video on this channel, I'm going to go deeper into something that most defendants discover only after it's too late. There's a significant gap between what your attorney investigator is doing and what actually needs to happen for your case to change. And there's something that your attorney is not allowed to tell you that you need to know. That is in the next video. Subscribe now so you don't miss it. I am Michael Quiel. I will see you in the next one.